The defense captures you on surveillance video. Is your case over? Is your credibility shot? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The defense captures you on hidden surveillance video, doing certain activities you claimed you couldn't do. And now you're thinking, oh my God, my case is over, my case is shot. Well, maybe yes, but then again, maybe no. The reality is that you have an opportunity to explain what you are doing and why your activity level has now increased. You want to be able to show to the jury and explain to them that you were trying to get back to society to participate in activities with your family. So just because they capture you on hidden surveillance video doing certain activities you originally claimed you couldn't do, doesn't necessarily mean that your case is over. Have more questions? Keep watching these videos. I'm Gerry Oginski. Have a wonderful day. Objection, Judge. He's being a ball buster. Is that an appropriate legal objection to make at trial? Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, that is not a proper legal objection. Being a ball buster? I never heard of that. Well, everybody knows what that means, right? He's being a pain in the ass. And now he's busting somebody's balls. He's being obstructive. He's being just a pain. Well, the attorney might get frustrated and might blurt that out. But actually, that's not an appropriate objection. Judge, he's being obstructive. Yes, that's an appropriate objection. Judge, now I can give you many different options on what to say about the type of objection he should be making. But being a ball buster? No, that's not one of them. Want more information about how these great cases work? I invite you to continue watching these videos. I'm Gerry Oginski. Have a wonderful day. Judge, I object. The defense attorney is being a total schmuck. Is that a proper and appropriate objection to make during the course of trial? Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is no, that is not a proper legal objection. It's obvious to everybody in the courtroom that this guy probably is a schmuck. You don't have to announce it to the world. And clearly this attorney is frustrated and now has blurted out the obvious that guy's a schmuck. Okay, everybody knows that. But what do you accomplish with that? What's the judge going to say? Yes, you're right? No, he's not going to say that. He's going to say, counselor, that's not an appropriate objection. Make an appropriate objection if you have one. Want more information about how these cases work? I invite you to keep watching these videos. Have questions about your matter? Call me, 516-487-8207. I'm Gerry Oginski. Have a wonderful day. Objection, Judge. The defense lawyer is giving hand signals to his client on the witness stand. Is that a proper objection? Want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Actually, that is a proper objection. If I notice that the defense lawyer is making certain hand signals while I am cross-examining the doctor on the witness stand, you better believe I'm going to make that objection. Judge, the defense lawyer is making hand signals. He's signaling his attorney, signaling his client on how to answer the question. And now the judge is going to look at him, and if he doesn't see it, he's now going to warn the attorney, don't do that, counselor. Why not? Because it's like grade school. Judge, he's tattling on me. I don't understand. Well, guess what? The judge doesn't want this to happen because he doesn't want the defense lawyer to signal and suggest answers to the witness on the stand. That's it for today's video. I'm Gerry Oginski. Have a great day. Objection, Judge. The defense lawyer is being a whiny crybaby. Is that an appropriate objection to make during trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, it is not an appropriate objection. Everybody in the courtroom will know that the defense lawyer is being whiny and objectionable. Why? Because he's asking questions that are just whining. Judge, can you do this? Judge, can you do that? Mr. Witness, can you do that? And you know how ingratiating, how annoying it is. Well, guess what? That's not an appropriate objection. Judge, that's an improper question. Judge, that's irrelevant. Judge, I object to that form of the question. Those are proper objections. But whiny? No, that's not one of them. Have questions about your matter that happened in New York? I invite you to pick up the phone and call me. 516-487-8207. I'm Gerry Oginski. Have a wonderful day. The defense lawyer wanted to shut down my website. You want to know why? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. This was at the very beginning of the internet. I had posted something about the topic of a case we were ready to try involving anesthesia errors. And now the defense lawyer found it and went to the judge and said, "Judge, you got to shut down Mr. Oginski's website." I said, "This is ridiculous, Judge. Even if I were to do that, this article already appears elsewhere, all across the internet. And shutting down my website will have no effect whatsoever on whether jurors can actually find this. Besides, they shouldn't be searching, they should be listening to your instructions, Judge." So what did the judge do? The answer is, we wound up settling the case before the judge ever had an opportunity to make that decision. You want to learn more about how these cases work? Then I invite you to call me at 516-487-8207. I'm Gerry Oginski. Have a fantastic day. What exactly is a deposition? Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. A deposition is pretrial questions and answers that you give in your attorney's office. There is no judge present, there is no jury present, but there is a court stenographer there to record all of your questions and all of your answers. This is sworn testimony and carries the same exact weight as if you are testifying at the time of trial. So, what's the difference? The difference is this takes place during the discovery phase of your lawsuit, where the opposing attorney gets to question you about things that happen in your own words. What happened to you? What effect did this have on you? What injuries do you have now as a result of whatever happened? So why do I share this information with you? To help you understand how these cases work in New York. That's it for today's video. I'm Gerry Oginski. Have a great day. What exactly is medical malpractice? You know, you hear me talking about medical malpractice cases all the time. What does it really mean? I'll tell you what it means. Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Medical malpractice is really nothing more than medical negligence. And what's negligence? It's carelessness, medical carelessness of a professional. It's a violation from the basic standards of medical care. That's what it is. And if we can show that we are slightly more likely right than wrong, then what the doctor did was, in fact, careless and violated the standard of care, then we look to see whether or not that carelessness was a cause of your injury. And are those injuries significant and or permanent? That's what medical malpractice really is. Have questions about your matter? Then I encourage you to pick up the phone and call me at 516-487-8207 or by email, Gerry, Gerry, at oginski-law.com. Do medical malpractice lawyers charge by the hour? You want to know the answer? Come join me for a moment as I share with you exactly how they charge. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, we don't charge by the hour. Instead, we only get paid if you are successful. Only if we get you a result. Only if you get money as a form of compensation for all of the harms, losses, and damages you receive because of a doctor's carelessness. That's known as a contingency fee. If you lose, we get nothing. We get none of our expenses paid back. The only time we get a fee is if we are successful for you. So why do I share this great information? So that you have a clear understanding of how these types of cases work. Have questions about your matter that happened in New York? Then I invite you to call me at 516-487-8207. I'm Gerry Oginski. Have a great day. What happens if we can't find a medical expert to support your claim, your medical malpractice claim? Can you still go forward with a case? Want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is no, we cannot go forward with your case. In New York, we are required to have a medical expert confirm, number one, that there was medical carelessness. Number two, that carelessness, those violations from the standard of care, were a cause of your injury. And three, that those injuries are significant and or permanent. Only if all three elements are present, with a medical expert who confirms all that, only then are we permitted to go forward with a case on your behalf. Have questions about your matter that happened in New York? Then I invite you to call me at 516-487-8207. I'm Gerry Oginski. Have a wonderful day. During a civil lawsuit in New York, how does a jury know whether or not a witness is lying? Do they get hooked up to a lie detector test? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. No, there's no lie detector being hooked up to anybody. How do they know? Well, if an attorney is able to show that there are contradictions in their testimony, that's one clear way to show that they may be less than truthful. Actually, your gut feeling tells you whether or not the witness is lying. You get to see their body language. You get to see how they respond. And you, as a juror, can actually make a decision on your own about whether or not you believe a witness is lying. That's how you do it. Not by lie detector tests. It's what's in your gut. Have questions about your matter? Then I invite you to call me if your matter happened in New York at 516-487-8207. I'm Gerry Oginski. Have a wonderful day. I want to show you a behind-the-scenes look at some video I'm creating today. So I have some friends that I found where I'm shooting some video. There's one dog, and there's a second one. This one happens to be blind. And I have to tell you, I was talking about mediation, and I put the dogs to sleep. That was remarkable. They loved my story so much. It was a bedtime story all about mediation. Actually, the dogs were just having a great time listening to the waves coming in while I'm waiting for my wife to come back from picking shells, and I had a few moments to share this great information. A mediation is a private settlement discussion with a judge that takes place outside of the courtroom, outside of court, and the parties get together and try and negotiate. And if they are successful, then your case gets settled. If not, you know what happens? Now your case continues on to trial. And I was trying to tell the dogs that, and guess what? They fell fast asleep. Hopefully you don't. Have questions? Call me, 516-487-8207.